Did you guys have clients, or were you starting from zero? Curious. And then how did you
We did not start from zero. And as I said, I was very observant of my fiduciary duties to my partners. And again, I love Holland and Knight. It was a great place for me during those 28 years. So I did not do anything to recruit anybody, any client, until after I left. And I'll just share this one little thing. When I did give my notice, the reaction was, well, that's a bold move. And that was kind of interesting. And I think it was. I referred to it as jumping off the cliff. But the nature of my practice, and I mentioned most of my work was coming from outside the firm. I'd say the split was probably in the last 10 years of my time there, probably 95% of my work was coming from outside the firm.
Welcome to the Founding Partner Podcast. Join your host, Jonathan Hawkins, as we explore the fascinating stories of successful law firm founders. We'll uncover their beginnings, triumph over challenges, and practice growth. Whether you aspire to launch your own firm, have an entrepreneurial spirit, or are just curious about the legal business, you're in the right place. Let's dive in.
Welcome to Founding Partner Podcast. I'm your host, Jonathan Hawkins. This is a podcast where I get to interview founding attorneys and hear about the firms that they've built and are building. And today's guest is Laurie Webb Daniel. She is an appellate lawyer based here in Atlanta. Appellate only, I believe. She'll tell us about that. But she's a former big law lawyer that went out and has started building a pretty impressive appellate practice. So Laurie, welcome to the show.
Thanks. I'm happy to be here. And hello, everyone. Yes, I am an appellate lawyer. I did leave big law 4 years ago to start an appellate boutique. But I have to say this. It's the role of the appellate lawyer, but it's not always in the appellate courts, just to make that clear. We say we are a resource for motions, appeals, and strategic trial support in high-stakes litigation. It's a bit of a mouthful, but it does kind of capture the various kind of aspects of our practice. So we are focused and skilled at conveying a winning message in a few words or a few pages, whether oral or written, but we do trial support, and we do love to be in the trial courts and are able to collaborate with very fine trial lawyers. That's the most fun ever.
And so, let's dig into that a little bit. And by trial support, I mean, I call it, you're like embedded in the trial. You're at the trial, basically helping preserve for appeal. Is that how it works?
Well, it's more than that. And frankly, I don't really like the term embedded appellate counsel. You hear it a lot, but embedded, I mean, that for me is kind of weird connotations. Actually, it's more of a partnership with the trial team. We are a member of the trial team. We usually, with rare exception, enter an appearance in our counsel of record along with other firms. It's always other firms now that I left the big firm. And in fact, it was that way even when I was in a big firm practice. Most of my work was coming in from outside the firm, and I was working with other firms. There may be reasons for that could be explored at some point, but the fact is that was the nature of my practice in the last, I'd say, probably the last 15 years of when I was at the large law firm, even though I headed up the appellate team. And they were just, it's just the nature of big firms, I think. Yeah. But it's fun. So it's not just monitoring, it's actually collaborating with the trial team.
All right, so let's dig into your firm. So I know it's not just you, so tell us, how many attorneys, staff, what's your setup?
We have 8 lawyers now and 2 staff members. I think I need to add a few more on the admin side. It's a really fun practice, and I'll roll back just a little bit to give a little background because I think that might be helpful. So I have a boutique practice. I started in a boutique firm, actually a litigation firm, and it was about a 10-lawyer firm, high-end litigation boutique in Atlanta. Everyone else were trial lawyers. I mean, they're excellent. American College of Trial Lawyers, really just tops. And that niche, this is back, it started in the 80s. And at the time, appellate wasn't really recognized as a specialty, but it was kind of my focus as the law person on the team. So these great trial lawyers had a different skill set. They could slice and dice anyone who's on the witness stand, give a powerful closing argument. But I was really good at working with them as the law person on the team. And often it was right from the start, kind of figuring out the legal strategies. So 12 years into that practice, we merged that firm into Holland and Knight, a great firm. Nothing but good to say about that firm. And at that time, Holland and Knight was just getting ready to launch into a more national presence. It was the largest firm in Florida at the time. This was 1994. So at that point, the firm was growing. I reached out, connected with a lot of other lawyers as they were coming in, new to the firm. So it was kind of an interesting dynamic because it was rapid growth in the big firm arena. And I took advantage of that to the benefit of the firm by really networking quite well with. When we would add a new office, I would immediately welcome people in and establish relationships. So back in those earlier days, and I merged in as an equity partner. I was lucky that way. It's different if you come up as an associate and make partner in a big firm. That's a whole different deal. I merged in as a partner, but it was wonderful building relationships. So I was doing the same thing with various offices in that firm. We brought in New York. I made a lot of good connections with the New York office, LA. And so because they knew me and they were coming into a big firm, and I would give them the pitch on what I did. Law person, yes, I can help you. I can help you with motions, appeals, strategic trial support. And it was great. It was beautiful and a lot of fun. And after just a few years, I was made head of the appellate team. But it was a Florida-based firm initially. Now it's not. But Florida, Texas, and California were the early states that view appellate as a specialty, and they have board certification for appellate lawyers. So this was my practice niche, was a good fit with that firm. It was wonderful. So it was from that background. And then, as I said, later, as my reputation grew, I started getting more and more work from outside the firm. Roll forward 28 years of being equity partner at the big firm, which, again, great firm. I started thinking about those boutique, those days in the boutique, and it's a different type of practice. And I started thinking about it and eventually decided it was time. It was time to launch my own firm with the niche practice that I had developed. And so I did 4 years ago. You asked about how many. So at the time, it was my number one guy at the big firm who was expressing some desire to not be in a big firm. I did not recruit him. I have to be clear. I observed my fiduciary duties. But eventually, when he said he was going to leave, and I said, well, you know what? Don't leave without me. So the way I put it, this is a visual image, and I think it kind of works. Matt Freelander and I held hands, jumped off the cliff, landed in deep water, quickly swam to the top, and have been doing swimmingly ever since. It was scary, but we were ready. We started. My daughter, who just finished University of Chicago Law School, came in with us initially, and then we added people. So now, we've got 8 lawyers, and I can tell you about some recent hires, but I don't want to just ramble. If you've got
So I want to go back. I think it's interesting to me, and I'm curious. When you were initially at your boutique, and it's really, I know that you were catching Holland and Knight on the upswing. Mm-hmm. But it's a different culture going from sort of the small boutique where you get to run the show to all of a sudden you're at a big firm that has the headquarters somewhere else. How was it for you? I know you very quickly made connections, but was it culture shock going from the small place to the bigger shop?
Well, people used to ask me, what's it like to go from your own firm into a big firm? And at that time, Holland and Knight I went from a 10-lawyer firm to probably 450 lawyer firm. Big contrast there, but I said, well, it still feels like my own firm, and that's the way Holland and Knight was when I joined, and I was in the leadership early, and very much involved in the growth, and I loved the firm, and I still do. It's just I told Holland and Knight when I left that I wanted to be partners just in a different way, and we do sometimes still work together.
So I don't know how much you want to go into this, but I imagine being a partner in a big firm it's a lot. I'll just say that. because you have to do a lot of work. You got to do all this other stuff. You got to politic. You got to do all these things. And then you've got all these offices spread across the country, maybe the world. How is that to manage?
Well, I was not only head of the Holland Knight firm-wide appellate team for a bunch of years, I also headed up the Atlanta litigation practice group. So, I was helping manage, trial lawyers who were not litigators. And there was growth, and I'm thinking, why did they put an appellate lawyer? We're like kind of nerdy and, not usually what you'd think of as being that, head of a general litigation group. But I think it worked really well, partly because I do have a love of connecting with people. And so we were successful. I did that for 7 years. It was a lot. I was fortunate because of the way my practice grew, and that when I merged into Holland and Knight, I already had a practice, but it wasn't originating my own business back in those earlier days. I was good with networking and getting relationships. But it's just a matter of enjoying what you do and enjoying the people you're working with, and that's what I did. I sought out again was relationship building, and then was able to pull people together when I was doing the more challenging practice group management, because that, as far as economics, was more valuable to the firm than firm-wide appellate, because appellate wasn't viewed as in terms of profit. The office performance was, and there were numbers that came out. But I did try hard to have some collaboration within our office to do what they call it, cross-selling, whatever, so people would get to know each other. I had meetings, I called it Dive Surprise, where I bring in takeout food from a different restaurant every month to kind of lure people in, with guess what we're having today, one, it might be the Varsity, or it might be Desta's Ethiopian Kitchen, or it might be whatever nobody knew. Anyway, that worked. So it's basically, again, it comes down to relationships and reaching out, connecting with people.
So you were at the small firm, you were then went to the big firm. You were there for 28 years, so completely different. And then 4 years ago, you started your own. And as you said, you jumped off the cliff. So again, almost another culture shock moment, maybe, because I personally know that just starting a firm, the story is like, if you need something, it's just you call down the hall and it shows up magically when you're at the big firm. When it's your firm, you got to put the stuff in the closet to go get. So what was that like?
Yes and no. It didn't always magically show up at the big firm. Just, you had to kind of know your way around and how to get what you want at a big firm. If, for example, you want a sponsorship or something like that. You have to justify things in a big firm. There was some pretty darn good administrative support though there, and that's the thing I miss the most. It's like, we've been successful. We've been really successful. Maybe beyond my hopes and dreams even. But with the success comes the challenges of managing it and making sure you've got enough time to do the best client work possible. And we do very intense brain work that requires us to think and focus and not be interrupted all the time. And it's hard to do both. So that part is the biggest challenge, is getting the admin. I've got a wonderful administrator, super smart, super big problem solver, just what you want. The problem I have with her is she doesn't work full time. So, I need 3 of her full time, it feels like. So we're looking at getting some more administrative help. That is the number one challenge for me, to be able to get the quiet, calm brain time to dig in on a challenging appeal, and yet manage the nitty-gritty, how to collect on our AR.
Yeah, so that's the next question. So you talked about the administrative part. What are some of the other differences that you immediately saw from the big firm to having your own shop again?
Yeah, so one thing, I wanted to avoid the, BS, red tape, whatever you want to call what you have to do in a large institution, whether it's a big firm or whatever. You have to go through certain channels, get certain approvals, whatever. And I mentioned sponsorships. And I've felt that a lot of times it's not just my former firm, I've seen this in other big firms, that if it's direct client relationship where you're going out and targeting some big client and doing a spiel, then it's fine. They'll pay for your travel and, the big dinner and wine dine, whatever. If it's a sponsorship, they don't. And this is it was harder, very hard. And it's because a lot of lawyers don't get referrals from other lawyers. That's not a big source of, generating origination. Not so for me, because as I said, I collaborate with other lawyers. And sometimes, we have great relationships. It's almost always seamless. And in a way, it's sort of like they realize that having an appellate person who they can communicate with and can relieve them of certain burdens that they may not like. They may not like doing charge conferences at a trial. Most people don't. I don't even like it, but I can do that so they can think about their closing argument. So I get a lot of referrals from other lawyers, from trial lawyers, but I wasn't getting support for that outreach because most of the lawyers in the firm don't get referrals, that many. And so that was a difference. And so coming down to sponsorships, starting a new firm, I needed to get the name out, get the firm's name out. I had my name out there already, but I needed Webb Daniel Freelander to be out there as a firm. So I had the freedom to just say, okay, yes, I'll sponsor, whatever. And I wanted to do it at a big level so people would say, and I'll just say this, 3 years out, last year, we were ranked by Best Lawyers on a national tier. I believe it was a tier 2 nationally as an appellate firm nationally.
Nice.
Yeah. And that's just, an indicator of that we are getting that we're small, we're getting known, not just in Atlanta where we're ranked in the top tier, number 1 tier in appellate, but also nationwide. And that's a big difference. I was ranked in Best Lawyers and Chambers and all at Holland and Knight, but it was harder. It was harder for me to get what I needed as far as marketing.
So let me ask, so you're ranked nationally. Do you have a national practice? Do you travel for your work, or is it mostly in Georgia?
I do. We have been based in Atlanta and have a very strong practice there. We also, though, have been known regionally, 11th Circuit. I started off doing mostly federal appeals for the first 15 years, and then the state. It's been pretty even since then, but we do a lot. I've got clients in Alabama and Florida as well as Georgia, but also, yes, nationally. I had a big case out of Colorado recently, appeal, and we got them elsewhere as well. And I will take this opportunity to mention about my recent hires because it's been a development that I wasn't really looking for, but I think is good. And we took advantage of the way the dynamics in the legal world now. The big one is the DOJ, and there's been a lot of exodus from DOJ with a lot of top talent. So we now have a strong presence in South Florida because I recruited the appellate chief and the deputy appellate chief out of the Southern District of Florida. Fabulous lawyers, amazing experience in the 11th Circuit. Dan Matskin, who is the former appellate chief, managed 200 appeals last year in the 11th Circuit. And the government work is challenging. Both of them, prior to working for the government, had worked in private practice, and they both had clerked on, for 11th Circuit judges. So a good fit, but yes, we're moving big time in Florida now. There's a lot of work down there. It's competitive. It is very, very competitive market in the appellate arena, but we've got some good talent.
So was that a strategic hire or an opportunistic hire? And by that, I mean, were you thinking, hey, I want to expand to Florida, let's see what we can find, or just through prior relationships this came up?
It's more of the second. As I said, I wasn't really planning on doing a push like that now. Now, I will say we already have had and still have 2 Florida lawyers who are members of both the Florida and the Georgia bar. One, my Skylar McDonald, who's been with us almost since day one. She came on early, lives in Tampa, clerked for Judge Hull on the 11th Circuit. And so she works remotely but she's very involved in the local bar there. And Lee Kynes practiced in Tampa. His father was a very prominent criminal defense lawyer in Tampa. He was at Holland and Knight with me for a while, left long before I did, but has come back. So I had it in my mind that, yes, someday, but the opportunity came when the Trump administration started stirring things up at the DOJ. And then it was a friend I know who's a very prominent DC lawyer who knew Dan and sort of put us together. And yeah.
So you've had success with adding those folks. Has it made you start to think, all right, let's look at other places and maybe start growing that way? Or is it still just as the opportunities come across your desk?
I think more of sort of an organic growth, and I don't want to get too big. I do think, though, with relationships, and I'm finding we are being asked to go in and assist other firms because we work with other firms. It's not as critical that we are members of the local bar. If it's a state practice, federal practice, it's very easy. So we are being asked, and again, that's kind of a relationship building, kind of being a trusted advisor, which is a wonderful position. I love that characterization of our role, which we are getting more and more often, where a national company will ask us to come in and work with other firms in other locations. I expect that's going to continue to grow as we continue to develop the relationships and our reputation.
So let's go back when you jumped off the cliff with Matt. Did you guys have clients, or were you starting from zero? I'm curious. And then how did you
We did not start from zero. And as I said, I was very observant of my fiduciary duties to my partners. And again, I love Holland and Knight. It was a great place for me during those 28 years. So I did not do anything to recruit anybody, any client, until after I left. And I'll just share this one little thing. When I did give my notice, the reaction was, well, that's a bold move. And that was kind of interesting. And I think it was. I referred to it as jumping off the cliff. But the nature of my practice, and I mentioned most of my work was coming from outside the firm. I'd say the split was probably in the last 10 years of my time there, probably 95% of my work was coming from outside the firm.
Oh, wow.
So it was not appeals coming up through the firm. And under those circumstances, we went with the form letter that the firm sent out as far as us leaving, and the clients had a choice, but they all chose us, every one of them.
Yeah, I mean, that makes sense to me, especially if it's mostly work coming from outside. I mean, who else are they going to go with, right?
Well, I was, in the end, the last 10 years, I was essentially operating an appellate boutique within a large firm. And I mean, again, I was loyal to the firm. I wasn't trying to siphon anything off. It just came to a point, finally. I'll just put it this way. I was licensed to practice law in 1982. So roll forward, I was at an age where I needed to do it then or never.
It's funny, the reaction I hear from other attorneys who leave big law that they get, it's sort of mixed. Some of it is like, you're crazy to try it. And then others are like, please take me with you.
Yeah, I would think. Yeah, but it's again on a boutique. It's interesting to kind of see these articles that are coming out now, some on boutique practice, and I think the age of the boutique. I mean, as I said, I started in a boutique 40 years ago, but I think now it's a particularly attractive type of practice if you've got a specialty where clients want you for that specialty and they don't really care about the big firm. Now, where it's more of a challenge, where the boutique practice is a challenge, it's for, so I deal with a lot of really high exposure cases, $100 million cases, a lot. And not all that much, some of them are more, but big bucks. Sometimes the board of the client wants a big firm name. It's CYA, kind of. So there are some times when I don't get work because I'm in a smaller firm and, it's just not one of the big firm names and, it's high risk and whatever. But other times the clients, once they get to know you and know your work and realize you've got what they want, it's a good match, then they will go with you in an appellate boutique. So it's got to be, I think it's important if someone's going to break off and start a firm, to have some relationships already established, so that the attractive nature of a smaller firm is going to overshadow the risk that clients might feel when they're deciding who to hire for some big matter.
Real quick, if you haven't gotten a copy yet, please check out my book, The Law Firm Life Cycle. It's written for law firm owners and those who plan to be owners. In the book, I discuss various issues that come up as a law firm progresses through the stages of its growth, from just before starting a firm to when it comes to an end. The Law Firm Life Cycle is available on Amazon. Now back to the show. So you've got a cool story, so I'll lay the groundwork a little bit. So I think your dad was a lawyer, I believe, and then at some point, you've done this more than once, but at some point you got to argue a case in front of the U.S. Supreme Court, and then your dad accompanied you. Why don't you tell me about that?
Yeah, no, all right. So this is kind of a fun story, and I do enjoy telling it, and it's kind of wild. So when I was a junior in college, my dad always, as I was growing up, was a very prominent trial lawyer in Atlanta. When I was a junior in college, I started thinking, what was I going to do after college? So I asked my dad about, should I be a lawyer? And he said, no, you really should be a paralegal. All right. I'm thinking, what? Then I remembered, so he was a Southern gentleman, and he did not like to encounter a woman in the courtroom because he was used to opening doors for women, not fighting them. And I used to, refer to one woman in particular. He said, I overheard him say this. He wasn't talking to me, but I overheard him referring to her as that goddamn female woman lawyer. And I thought, I don't want to be a paralegal. I want to be a goddamn female woman lawyer. So I didn't talk to him anymore about it, finished college, waited tables a couple of years, saved my money, and went to the state university, the state where I was living at the time, and got a law degree. Well, anyway, somehow or other, my mom got me back to Atlanta, and I ended up actually going into practice with my father and my husband, by the way, and a 10-lawyer firm. And I was a law person on the team, and we had a case that got a mixed result in the 11th Circuit. And I thought we had a shot at a cert petition. I knew it was a long shot, but I said, look, there's a dissent from the denial of cert in this case on the same issue. Can I try? And they said, yeah. So I did up the cert petition, and it was granted. And then the question came, who was going to argue it? And Dad at the time was in his 60s. Hal was in 20 years younger than that. Anyway, I was still fairly early in my career. But anyway, I did. They said, yeah, I could argue it. So that was the day my father carried my briefcase in the U.S. Supreme Court. And let me say this about him. He was a great man, great trial lawyer. And he also had the ability to accept new views and change his mind. And he did. He changed his mind, and we worked really closely together. He was a wonderful mentor. And if you asked him before he died who his best associate ever was, he would name a woman who was not me, but a woman who's a partner at Holland & Knight now. She was an associate, and he would invariably refer to her because, she tried the last case he tried to a jury, and he loved her, and for good reason, she's excellent. Anyway, so yeah, that was kind of a sign of the change of times because, there were very few women in the courtroom in 1982. Actually, that was actually in the 70s when he made that remark to me. It discouraged me from being a lawyer. He thought I wouldn't be able to get a job. But
So tell me about going to the U.S. Supreme Court. What was that like for you? I can imagine how, nervous I would feel. Just overwhelming, probably. I don't know. Tell me about the experience.
Well, I thought it was fun. It was, it's kind of like standing in front of the firing squad. I was pretty young. I was really focused, really well prepared. I remember you go in and you check in down kind of in the basement with the clerk of courts, where the clerk of courts office was. And my opposing counsel was Hansel and Post. Did they go into Jones Day? I don't know. They merged in. I think it was Jones Day that acquired them. But anyway, I remember being behind him and going in, and of course, the people in the clerk's office thought I was his associate. And I said, no, actually, I'm the opposing counsel. And then, the protocol, it's daunting. Questions, Scalia was new. Kennedy and Scalia were both new, and they were on either side of the bench. And the Supreme Court, it's actually rather intimate. It's not a big courtroom, and the podium is very, very close to the bench. So you kind of have to turn when you speak to the justices. And Scalia just, he was like I say a bulldog. Anyway, it was like he grabbed onto my pant leg and just wasn't going to let go, and he kept wanting to, I kept answering he would do these hypotheticals, and I kept answering them, and then he change and get the facts weirder and weirder and weirder. And finally, I just got to say, respectfully, Your Honor, I disagree. It was intense. I would have liked to have done it again. I think my chances are very slim because of the way the Supreme Court practice evolved. And now it's really kind of a club of elite people and again, when you go to the CYA factor of clients choosing counsel, they just don't want to risk not going with one of those Supreme Court elite. And I'll say this, what's interesting, that the caseload in the Supreme Court's been diminishing every year, and it's, I think, at all-time low, at least I think maybe all-time low right now. Meanwhile, they've got these clerks. Each justice has all these clerks, and they have their year clerk, and so you've got all these former Supreme Court clerks out there going into big firms, and there's just not enough work. And so you're talking about competition. When they start coming down, I remember Miguel Estrada coming down, and I had a case, with him, actually against him one time. But I'm saying, Miguel, what are you doing down here? Go back to DC. This is not your territory. But in fact, it is. I'm seeing it, and that's kind of an interesting dynamic in the appellate world, because there's just not enough appellate work in DC for all of the top talent. So I've got to have that kind of as a competitive issue to a certain extent.
That's interesting. The other thing, and I'm curious your view on it. You've been doing appellate work for most of your career at this point. And my view is, I grew up as a business litigator, and occasionally we would have cases that go on appeal, no big deal, and we would just handle them. And so the idea of having the boutique that would come in, and the case, they weren't $100 million cases. That's for sure. So, so I'll put that out there. But the idea that, that you have these boutique appellate firm only, type firms, is that a new thing in your view, or in light of sort of the way you've sort of your career's gone?
It is new in a lot of areas in the U.S. As I mentioned previously, Florida, Texas, and California, not so new, but I think typically you'd see the established larger firms with appellate groups that would, have a practice. There are some appellate boutiques in California, some very fine appellate boutique, and more than one, I think, and also Texas, I know of some. But it's still not absolutely common. But I saw it, actually, it was my time at Holland and Knight when I learned about the Florida bar has a separate appellate practice section, and how it was recognized. So I decided to start the appellate practice section for Georgia, the State Bar of Georgia, and I did that like 25 years ago. So was building that as a niche, really for a good while now, which has helped, by the way.
So another thing I've seen is there are like one or two or three, I'll call them plaintiff side appellate lawyers, and then I don't know where you fall, but so you have the appellate niche, and then they've niched down even further. Do you have to pick a side in your view on that, or is it?
Oh, on personal injury, it's solidly defense. There's no way you could do it either way. Same with like my good friend Mike Terry, who's often plaintiffs, and I'm against them. I say sometimes we're a little bit like, I mentioned the U.S. Supreme Court kind of elite, what people want to go with the lawyers who routinely argue in the U.S. Supreme Court, who know that judges are on a first-name basis, or the justices, I should say, justices. There's a little bit of that going on in Atlanta because of some really, really, really talented plaintiff side appellate lawyers, which has benefited me as defense side. But that's in the personal injury space. But that's where you've been getting a lot of nuclear verdicts in Georgia, because the measure of damages is the enlightened conscience of the jury. Okay, so you got a good trial lawyer there, blame the jury, get $100 million. I used to do a lot of antitrust work and other types of commercial litigation where damages were economic. Now you've got to have some proof, some real proof of what, the losses are, and it's not so open-ended. So in that respect, yeah, the dynamics have actually been good for me. I don't get a percentage of the big hit, not even a reverse percentage. We got just today an opinion reversing $113 million jury verdict. And Matt Friedlander got this one, and he said, if I had this on a reverse contingency, I could retire. Yeah, Matt, we just don't do it that way. But,
well, you need to experiment. You need to experiment.
I have some, and I do have an open mind on that. It's easier said than done on the defense side.
Yeah.
But it's, like I said, we have an open mind. We want to make sure that our clients are, what works for them. We got to keep it at a level. I mean, right now, I'm the only equity partner in my firm. So that means I've got a payroll of keeping what I call the big brains, sometimes I call them the youngsters because they're all fun. They're all range in age from like 36 to 48. So got to make sure I've got the money in there for payroll. We did a lot of contingency work at Webb and Daniel, which was my dad's firm, Paul Webb and Hal Daniel, but and business cases. That was all business litigation. But there's a big investment for a small firm to do a business case on and we did a fair amount of plaintiffs work on the business side, plaintiffs and defense, but it's a much harder business model. And we do, at our firm, do plaintiffs work in the commercial space. Just can't do it in personal injury. But I do enjoy plaintiffs work if it's business.
So let's go back. So I want to talk a little bit about client development or business development. And you mentioned when you started your firm, you did some sponsorships and you talked a lot about relationships. But how have you gone about, again, you broke off, you started your firm. How do you get out there and say, all right, start sending me the work? What were some of the things you did that you look back and said, yeah, that worked pretty well?
Well, the practice has grown since I left a big firm. One thing, I've gotten a lot of referrals. As I said, I get referrals from a lot of trial lawyers. So does Matt. Matt's really good at it, and some others making those, establishing those relationships. Professional organizations are good, getting the name out. But I've always said, I said to my younger lawyers, if you get a good result, make sure people know about it. And it's not just tooting your own horn, which, you got to do a certain amount of that. I mean, you got to make sure people know about it. And if I get a media inquiry, if it's a big client, I have to get permission. But if it's something more general, I can comment. And even with the larger clients, like we had a media inquiry on a case that's been, one of several anyway. Reporter reaches out to me. I go to the client. They go, well, we don't usually comment. I go, well, how about this? How about if I just have something like I say to the reporter, our position is well stated in our brief. And then I give them a hint as to where to look in the brief. So it's not a no comment. It's a little something. And it's a quote. And the reporters like it. So then they reach out to me and then it's a win. If we won, then I can have a little more room on maybe, even if you just say, oh, we're very pleased with the thorough analysis the Court of Appeals gets, whatever. Anyway, that's good. But it's also making sure if you've got a win, if you've just gotten a good result in an issue that's important industry-wide, in this personal injury space, a lot of insurers ask us to handle the high stakes stuff, and let the clients know, hey, the court just reversed on this basis, or whatever you can, let the clients know, and then they come back or they tell other people.
So you mentioned earlier, there's some big clients that the boards want to do the safe route and go with the big firm. So I putting those aside, I imagine, I could be wrong, but I would imagine not being affiliated with a really big firm could also help in the business development, because people that may not have referred to you while you're at the big firm feel less threatened to refer to you when you're on a boutique. Has that been your experience?
I think that's right. I think that's right. And frankly, I am at liberty to set rates how I want to. And one of the problems that I got sometimes when I was managing the practice group, I'd say, okay, we've got to raise rates, and no, we're gonna lose, because they're you kind of worry a little bit, if you can be competitive even in a big firm. If you're not one of the top, New York firms, or it is competitive, they have competition too. So there is that price advantage to a certain extent. I need to always kind of assess where I should be on that, because, where is the market? Where is the place? But I've got payroll and I gotta, and if we're doing really good work, I hate losing out on a representation because somebody's going with a lower rate person. But, I'm not going to go down if I think it's not worth it. But I'll say this, I will sometimes give a break to a client that's got some reason why. There was a smallish law firm that got zapped with sanctions, and it wasn't, $100 million of sanction, but it was real money to them, and their insurer wasn't going to cover any further defense once they got zapped with sanctions, and they were on their own. And I just said, guys, I'm going to give you a break on this. This is not right. You shouldn't have been sanctioned, and we're going to fix this. And we did. I did. I got it vacated completely. I mean, it was gone. But I just wanted to. And that's an example of me, kind of the vision for our firm is we want to enjoy our practice, and I want to have the freedom to make those decisions. If I want to represent somebody like that, he wasn't pro bono. They paid some. But if I want to do that because I feel like it's satisfying to me to fix something, then I can do it without having to beg for permission.
That is nice. That is nice. So let's shifting a little bit. So real quick, just in the operations, again, in a big firm, you've got all this support that helps run the firm, and you can really focus on doing client work. But now that you're running the firm, you got to worry about payroll. You got to do this stuff. How do you balance the operations piece with the client work?
Well, client work comes first. So, in a way, it's not balanced. It's not balanced. And that's part of the stress. And I've always handled stress well. I'm type B, and that means I have staying power because, I don't know. I just don't get worked up much. But I will say there is some stress and feeling like I haven't caught up with the admin stuff. There's always stuff that I need to do. That's where I'll tell you what, I honestly think AI is going to help with this. And I did attend a program with some guys there talking about AI summarizing your emails and this and that. I mean, it's not like AI writing briefs for me. It's the admin side that I think I can get some further help. I probably need to hire some human to help with it also, but I really am very interested in AI to help with that side of the practice. But definitely the client work dominates. I'm just not gonna, and I'm doing okay, but it is the part where it doesn't keep me up at night, but it does, I don't like it. I need to get it a little more under control.
It's like, I've never worked at the post office, but I think it just never ends. The mail keeps coming, and you just have to keep delivering it. So
but it's a good thing. I mean, if I was sitting around and had time, on my hands, then I would have other problems.
So you've been at it for 4 years. You've had, great growth. As we're sitting here today, if someone else is out there thinking about maybe leaving Big Law to start their own firm, is there any advice that maybe you'd give them?
Yeah, I mean, this is general advice, but I think you have to start with a vision, think about what you want, big picture, and then you have to, it's a good idea before you leave to get some details there, flesh it out, what clients might come with you from the start, what's your marketing plan for getting new clients, Do you want to have a brick and mortar space, or do you want to, be more virtual? Does it make sense for you to spend the dollars on brick and mortar? For us, we wanted that. And I think it's a good thing for our firm. But those are the kinds of decisions, you pay attention to, revenues and expenses. Just kind of get some idea, do a business plan, and then maybe seek counsel from someone who might be able to help advise, a new firm launching. But I think it's a combination of vision and then getting some basic starts. You've got to be practical, and there's going to be a lag in cash flow, usually.
Yeah.
Get your lines of credit lined up. That's what I did. When I was at the big law firms, their partners get deals with banks on lines of credit. That I got that in place. I did do that. No breach of fiduciary duty there. But I got the line of credit in place and needed that. But it didn't take that long before the cash started coming in. But it was a lag, you got to send out the bills and wait for people to pay. And it started happening. But I would say that line of credit, yeah, definitely got to have that.
That is great advice. Great advice. Get it before it's hard to get it when you're self-employed.
Oh, not only that, after it got the term, 2 years into it, oh, well, it's ending now.
Yeah.
It's fine. I didn't need it, but at that point I didn't need it. But it was pretty funny. I got dropped. Of course, I got dropped when it wasn't at the big firm anymore. But that's fine. I got launched. That's what I wanted.
Yeah. So if you weren't practicing law, what would you be doing?
Yeah, I never used to think about that. And I'm not ready for that. I am not ready for that. I'm not retiring. People ask me sometimes, oh, are you still working? Oh boy, am I working. But I do now sometimes think about it. And so I'm a writer. That's what I do. I have to try to make the narrative interesting in the cases that I have, even if they're pretty dry. But I've got just this whole part of my brain that has novels sort of written, children's short stories over here. I don't know which side of the brain does that. But anyway, I would like to do that. I would like to do it at the beach.
That would
maybe someday. I will after a while. I'm not ready yet, but at some point and I may never really retire, but I'd like to have maybe a little bit more time for, such things as writing novels.
Well, that would be cool. Well, Laurie, I appreciate you coming on. This has been real fun. I liked hearing the story about Supreme Court. That was cool. Yeah. And what did you say? You wanted to be one of those goddamn female. Yeah, no kidding. Goddamn female woman lawyer. That's what he referred to this woman. He was talking to somebody. I don't know who he was talking to. I overheard this. It'll be goddamn female woman lawyer, and I guess that's what I am. Well, I'm not going to do it to you, but that would be a great title for this podcast.
Well.
So for anybody out there that wants to get in touch with you, maybe they got a case they want to associate you on or whatever, what's the best way to find you?
Well, you can Google me, Laurie Webb Daniel, and that brings up actually the website, which is webbdaniel.law. But even just my name does it on LinkedIn. I'm not as active as I am sometimes on that. And I try to have LinkedIn posts be actually interesting, other than just self-glorification. And so I do sometimes do movie reviews about lawyer-connected movies or some other things that are of interest that are not just self-promotion. But anyway, Googling Laurie Webb Daniel, attorney, Atlanta, pretty much pulls up more information.
Well, great, Laurie, again, thank you for coming on. This has been real fun.
No, it's been great. Thanks for inviting me.
Thanks for listening to this episode of the Founding Partner Podcast. Be sure to subscribe on Apple Podcasts, Spotify, or wherever you get your podcasts to stay up to date on the latest episodes. You can also connect with Jonathan on LinkedIn and check out the show notes with links to resources mentioned throughout our discussion by visiting www.lawfirmgc.com. We'll see you next time for more origin stories and insights from successful law firm founders.